I have said since the beginning that these lawsuits against the National Association of Realtors and associated brokerages have been nothing more than a cash grab. And today we have definitive evidence that that is exactly what these are. Brian here with Lamacchia Realty, and I have some interesting news to share about these lawsuits that just came through over the past couple of hours. And it's really stuff that has been happening over the past couple of days. So just to get you up to speed, the National Association of Realtors has settled in this landmark lawsuit along with the other brokerages. And basically there's a judge out in Missouri that controls the keys, so to speak, to all of this. And one thing I didn't realize is that this settlement that National Association of Realtors has entered into, along with the other brokerages, has provided them with a release of any claim for future lawsuits pertaining to this quote unquote conspiracy, right? The findings of the lawsuit in the first place was that these brokerages conspired to artificially inflate commissions, and that is why they are agreeing to essentially settle, because the jury came back and found them guilty. So now what's happening is all these other plaintiffs and all these other cases that are out there are coming out of the woodwork and desperately trying to put the brakes on this settlement, because it basically indemnifies all of the brokerages and the National Association of Realtors from future litigation. So it is a huge win for NAR if this passes. Again, I didn't realize that feature was in this settlement, but it appears that it is. So let's just get into the article and you'll see what I'm talking about here. After months of uncertainty, the real estate industry has a reason to celebrate, yay, or at least a little bit. Judge Stephen Bough has granted final approval to the commission lawsuit settlement agreements reached by NAR, RE/MAX, and Keller Williams on Thursday. As part of the settlement agreements, I'm not going to go through all this, but you know, it's a bunch of money, $418 million for NAR, plus $83 million, $55 million, and $70 million for NAR, RE/MAX, and Keller Williams, respectively. And with it comes some changes that are going to be made in terms of the way in which business is conducted. Now, what he did is he allowed 4 of these potential plaintiffs 5 minutes each to make their case in front of him as to why he should delay this approval. So let's take a look and see what they were presenting and why they objected to this settlement being finalized. So you have the Pulte Group, you've got a copycat lawsuit in South Carolina, you've got the Springway Center, which is a Pennsylvania copycat lawsuit, and then this one is the biggest one of all, in my opinion, is that you've got this Batten Homebuyer Commission lawsuit. So those are the 4 groups that went in front of the judge. Let's see how they fared. Okay, filing in mid-April, homebuilder Pulte Group explained that certain procedural factors have impacted the company's decision to remain in the case's settlement classes. Additionally, the firm noted that it was unsure of the quote, magnitude of its potential recovery, as well as the work that would be required to receive it, and whether the settlement will survive due process considerations are key questions that could determine the company's ongoing presence in the class. Okay, so let's dissect this a little bit. Magnitude of its potential recovery. That is code for money. That's what these people are after. Money. They could care less about the process and the changes that are actually coming to the industry. They just want their money. Let's look at the next group. The South Carolina objectors took a different tack and objected to some of the financial amounts of the settlement. In mid-April, attorneys for the objectors asked the court for permission to subpoena financial documents from Keller Williams, quote, for the purpose of evaluating the objectors' positions regarding any continuing objection and further to help provide the court with valuable evidence in ruling on whether to grant final approval of the proposed settlement entered into by and between Keller Williams and the plaintiffs. Let's read between the lines. What are they objected to? They want to do a financial audit of Keller Williams so that they can see how much money they have and ultimately get their money. That's what this is all about. Let's look at the next one. In a document filed on Wednesday, the Springway Center supported by South Carolina's objectors motion, writing that it was objecting to the, quote, fairness and adequacy of Anywhere's settlement amount. Again, what are they talking about? They're talking about the amount. They're not talking about, hey, my plaintiffs have been harmed irreparably, so we need to make some major changes to this. No, they don't care about any of these process changes. They want money. That's it. Let's go down. Finally, Mullis, who bought a home and sold a home, making him part of the settlement class as well as Batten plaintiff, filed his objection in mid-April, writing that the court should only approve the settlements, quote, if the settling parties expressly carve out claims asserted in the Batten action from the defined, quote, released claims or otherwise clarify that the settlements do not release damages claims related to transactions in which class members purchased homes. Let's talk about that. You know, we got to have a carve out. Why? Because we are not getting any money in this settlement. This is about nothing more than the money. The reality is after these changes go into place, the real estate industry is going to be business as usual. In fact, the exact opposite is going to happen, and the impact it's going to have is home prices are going to go up, and guess what else is going to go up? Commissions. They are going to go up. In an effort to quote unquote change the industry, this guy Ketchmark has done the exact opposite. He's made it more difficult for buyers to buy homes. He's made it more difficult for sellers to sell homes. Oh, and in the process, he's actually given real estate agents a pay raise. Is this fixing anything? Absolutely not. This guy brilliantly saw an opportunity. You know, he is a personal injury lawyer. You know, this is what he does. He's like, can I find any victims out there? Let's see if I can go rummage some up. You know, it might be at a dinner party with a friend of mine, talk about it. Oh, did you sell a home? Oh yeah, how'd you feel about that? Well, I didn't feel good, but you signed a legally binding contract and everything was disclosed and you had the opportunity to negotiate. But you know what? Let's just try it anyways and see what we get, right? And they did it and they were successful, and shame on NAR for settling. You could have taken this to any court. They would have seen the evidence and they would have 100% thrown it out because there is zero evidence of collusion and conspiracy. You know where I stand. Let me know down in the comments if you think this is a joke like I do, or if you think this is meaningful, or if you think that there's going to be some meaningful changes coming out of this. That's all I have for today. Thanks for watching. Take care.